from Suban and Associates, and Aparajita, sorry Ritika is not there, Aparajita, a managing associate from Lex Orvis. Welcome all of you. We are going to discuss the dimension of IP in the world of metaverse. Now, before we go into the subject, I just want to know how many of you have done pre-wedding shooting for your marriage? Anyone? No? How many of you would like to create your avatar and on your 25th or 10th or silver anniversary or maybe golden anniversary would like to create your avatar, dress it up in a sabyasachi lehenga and all your desired dress materials and costumes and accessories and create an invitation for your nears and dears and in a metaverse and kind of use it for invitation or a movie, or how many of you will be interested? Good. So I know many of you. So this is what we are going to discuss. Why I'm discussing all this is it is a super interesting subject. So when we are going to talk about metaverse, we are going to talk about the immersive virtual reality, where we can create our avatar. We can ask it to go from one platform to another platform, buy the purchase the costumes, purchase whatever they want, whatever brand they want, use it and promote it in whatsoever manner it wants to do. But in doing all of that, we all know IP is going to be super important aspect of it. So we are going to discuss that how metaverse is going to impact the IP prosecution and IP litigation aspect. And before we do that, I would just like to share a few things. The value of metaverse, which has been, according to Bloomberg, by 2024, the business is going to be approximately USD 800 billion. And according to JP Morgan, USD 1 trillion annually. And according to Goldman Sachs, USD 8 trillion. So you can understand the importance of, economic importance of metaverse and how commercially it is going to change the entire era. So now let's start with the questions. So Sriram, what is your understanding of metaverse and what kind of trademark filing strategy would you adopt and advise your client while dealing with metaverse?
Very good afternoon to everybody. Privileged to be amongst all of you. So metaverse is quite an emerging field. It's a new concept. Many countries are now adapting their laws and adapting to this new concept. And there are some comprehensive guidelines that they are considering to deal with this situation. A lot of countries have not still come up with much, but countries such as European Union and Korea and a few other countries have already framed certain guidelines as to how to file trademark applications considering from the perspective of metaverse. By and large, I would say that the focus has been on how to draft the specification of goods while filing trademark applications. The Korean intellectual property in 2022 came up with certain guidelines as to how specifically the goods should be worded. Now, a common perception would be downloadable digital goods authenticated by NFTs. But that is not acceptable anymore. One has to absolutely be very specific as to which are the goods. So downloadable, it has to be, one cannot even say virtual goods. Virtual goods were acceptable, but after 2022, it has to be virtual clothing or virtual furniture. So one has to be very specific, even if it goes under class 9 or class 42, which are meant for software. And importantly, under the new system, virtual goods are considered different from the physical goods. The same category, virtual clothing is not similar to physical clothing. So they are considered as different goods. European Union has also gone on the similar lines. They've said that downloadable virtual goods has to be specified, namely virtual clothing, etc. Now these are some basic guidelines as to how to file trademark applications for those people who intend to use their trademarks on the metaverse, who either intend to or already started using their trademarks on the metaverse. Now, given the increase in availability of branded virtual products and the possibilities of violations or infringements that are going to shape up, it is extremely important to understand how people who do not intend to use their trademarks on metaverse are also going to deal with this situation. Because every company, every proprietor or every individual may not necessarily want to put up their trademarks on their brands or their products or services on the metaverse. So, but there is still a possibility that their trademarks may be infringed on the metaverse. A common defense that a person who's using on the metaverse takes is that my products are either in class 9 or class 42. Your products, say for example, they are clothing. Clothing is the most common example because of the early prominence of fashion industry in the metaverse or vice versa. So your products are in class 25. So the products are entirely different. Unless the trademark is recognized as well known, it becomes very difficult for such users on the physical space to enforce their rights against people who are using it on the metaverse. So what can they possibly do to preempt these kind of situations? There are two aspects here. First one is, my opinion on this is that one can possibly file as many different types of trademarks as possible. So Section 21ZB of the Trademarks Act says it includes shape of goods, packaging material, combination of colors, etc. Now, it is not necessary that when a product which is there on the physical space is replicated on the metaverse, it's not necessary that it is replicated along with the trademark itself. Just the product may be replicated, which is absolutely identical to what belongs to the original proprietor. So, say for example, it's a beverage bottle of either an alcoholic or a non-alcoholic beverage. It's a bottle. So if there is something unique about the shape, provided it is not prohibited under Section 9 of the Trademarks Act, shape of goods. So if there is something unique about the shape, it is advisable to file a trademark application for those shape of goods or, for example, layout trademarks for shops or for salons or restaurants or whatever in class 9 as well. Secure a registration in class 9. You may not be using it in class 9, but registration by itself is a presumption of validity of the trademark. So it is important that that way you broaden your rights, you get a registration in those relevant classes, and if you anticipate or foresee that your trademark will be infringed in the metaverse in the future, it will be easier for you to enforce your rights in either a litigation or an opposition proceeding, either ways. There are so many examples of non-conventional trademarks. So it's a good idea to go non-conventional as well. Secondly, this was about the trademark. Next is about broadening the specification of goods or services. Like I already mentioned, you do broaden your specifications, you file in class 9, you file in class 42, but there again it is advisable to keep it very, very specific. So you say downloadable digital goods, namely virtual clothing, downloadable digital goods, namely virtual furniture. So irrespective of whether you're using it in that class or not. Of course, there is a challenge. There is a risk that you file a trademark application. If it is inherently distinctive, it proceeds to registration. Once it proceeds to registration and 5 years thereon, if you have not been using it, it might be challenged in a non-use cancellation petition, but still, that's for every business or every proprietor to assess the situation and use their own discretion to come to the conclusion or to handle how they are, or to assess how they are going to protect their trademark. That's one thing. And secondly, it is equally important for people who are using it on metaverse, genuine users on metaverse, to consider filing their trademarks also in the relevant class of those goods and services in the physical space. Because if trademarks can be infringed on the metaverse, there's a converse of that also possible. So if you are say, if you are offering downloadable furniture, if it's there on the metaverse, you file it in class 9, but then it's also a good idea to file it in class 20 and secure a registration in that.
So what you're suggesting is that in addition to the physical world goods and services, for virtual digital assets, you should file all your prosecution and trademark applications in class 9. So is there any guideline from WIPO while filing the digital assets or digital goods in class 9?
There are guidelines issued by various countries, jurisdictions. European Union has issued guidelines, as I already mentioned. So we could adopt those guidelines. India, by and large, may follow the European Union, and it may be more or less similar to that.
Thank you. So it's interesting to note that you may have to do an additional protection for your brand, but as you have rightly said, so far as infringement action is concerned, you may still use your real world registrations for the goods and use it for claiming your right of infringement in the virtual world.
Absolutely.
So I come back to you, Aparajita. Do you have any thoughts on how are we going to handle the cases of infringement in the metaverse world?
Hi, so it's Aparajita this side. I had to slip in instead of Ritika, but I'll try to cover everything that Ritika wanted to say here. So as far as enforcement is concerned, the main issue that is basically differentiating metaverse from a physical world counterfeiting or a enforcement that you see in a physical world is that IP rights are territorial in nature, while metaverse by its nature is non-territorial. Anything that happens at metaverse, it is crossing boundaries. So the basic and the first question that comes in mind and the first challenge that comes is, how is the jurisdiction going to be taken? Who is going to decide where to file the suit for infringement, be it for copyright, be it for trademarks? Most of these platforms, metaverse platforms, they will have certain terms and conditions that you would be agreeing to whenever you join these platforms and start to do your activity. And a lot of these terms and conditions are going to mention that so-and-so is going to be the jurisdiction. The question is it fair that everyone sitting around in various countries, for example, a cause of action has arisen in India. And in India, your rights are being affected, but the platform says that the jurisdiction will lie in US. Is it fair for an Indian, probably a startup owner to bear the costs that would come in a US litigation suit? So this is one challenge that is coming that, in my opinion, it should be allowed that wherever the cause of action is arising, wherever your rights are being affected, the person should be, the right owner should be allowed to file the suit there and should not only be bound by the terms and conditions that these metaverse platforms are going to make you sign. So that is something that we need to think about, how to create certain regulations, how to probably create an authority where cross-border disputes can be handled, so that this jurisdiction issue has to be somewhere settled. Otherwise, it is going to create a lot of issues for people who may not be able to go in a different country and file a suit for infringement there. The second issue that is created is that, as he already mentioned, that you have to register your rights. You have to register your rights, not just in the classes. For example, probably you're a fashion designer or any kind of business owner. So not just the relevant classes, for example, class 25, you can also go and register in class 9. Now the other thing that comes up is, what if your brand is being infringed for something which is unrelated to your business, not at all related to your goods and services? In those cases, you will have to rely on your well-known concept. But not in all countries, the well-known concept or the trans-border reputation concept may be as developed as other countries. So for example, in India, as per Section 11, you need not even have a use in India. even on the basis of trans-border reputation, something can be declared well-known. Section 11 allows that. But then that may not be possible in any other country. So, because the well-known concept is not developed in other countries, say for example China and US, it is not easy to get an infringement suit successful on the basis of trans-border reputation. So in those cases, there would be issues in case your trademark is being infringed for unrelated goods and services. So there is this issue. The other issue that may come up is that in case you have not got your IP registered and you only wish to rely on, say, a passing off case, it will be a little difficult to establish passing off in case of metaverse, because then, one, you will have to establish your goodwill and reputation qua the metaverse platform, qua the virtual goods. The other thing, misrepresentation or damages, all these three factors you will have to prove in terms of metaverse. So yes, registration is important because in case of unregistered rights, you may have issues in establishing a passing off case. Well-known mark in case, it's very important. In whatever jurisdiction at least you are present in, make sure that in case you think your trademark is something which can be declared well-known, file an application for that. In India, you can do so. You can go ahead and get it declared as well-known. And jurisdiction issues, as we discussed, we will have to work out something related to jurisdictional issues, how to manage that.
So let me ask you a live question that you must be knowing about Aramis brand, right? And very famous purse of that is Birkin bags. So if someone uses Birkin bags as Meta Birkin on the metaverse, would it be an infringement or not?
Yes, and it has been held to be infringement. So in this particular case, Rothschild, which was the defendant, they were they were selling NFTs of Birkin's bag, so naming it as Meta Birkins. And there was some, fox fur covered images of the Birkin's bag, and they were being sold, these digital images were being sold as NFTs. So Hermes, they had filed an infringement suit for trademark infringement, for dilution, unfair competition, and it was held to be infringement even in the virtual space because you are, and in fact the domain was transferred, in fact in this case, 133,000 USD were awarded as damages. So yes, even in these cases, in case you are putting something like Meta Birkins, because you are using the trademark Birkins, you just added a Meta because you are putting it on Metaverse platform. So yes, in these cases, infringement was made out, and in case anyone is selling digital images also and infringing the brand in this case, infringement suit can be made.
I'm getting very curious. So the general principle of infringement was applied and the damages was also awarded. Do you want to discuss also any case where the fair use or, the first sale doctrine was upheld in any of the judgment? Do you have any thoughts on that?
See, in cases of copyright also, the general principles that we follow in copyright will apply even in case of metaverse. The issue, again, that would come in copyright cases would be depending upon local and national laws, because again, if there is a cross-border dispute, different national laws will be there and every country will have its own fair use principles. So again, the same issue will come in copyright disputes as well, not just trademark, that there are different national laws and different local laws. So how do you, in one country, something may be infringement, and in other countries, something may fall under the fair use exception. So in those cases also, there will be issues. Yeah.
So I just wanted to share one judgment here of Nike versus Stock X5, where Stock X5 was just the collector of the reseller of the Nike shoes, and Nike sued for using the shoes device. And the defense was, no, it is a first sale doctrine, and I am reselling the product purchased from the Nike, from the authenticated source, and therefore, even if I am using it in the metaverse, I am using it after purchasing and taking the pictures and creating whatever I want to create out of it, and therefore it will not be an infringement, and it was upheld to be so. So thank you for your comments on trademark infringement. We have a patent expert here. Hi, Jaya. What is your view how it is going to be a metaverse is going to be impacted in the world of patents?
Thank you, Mamta. So there are some challenges in procuring patent protection for these technologies, essentially because of the nature of the subject matter itself. But to appreciate the challenges in patenting of technologies relating to metaverse, maybe we can just take a brief moment to see what these technologies really are. Some examples of that. So essentially, you will have technologies that will create a representation of the virtual environment, and then you will have technologies that will interface a user with that virtual environment. So this will be your display, camera, your headsets, gloves for haptic sensations and things like that. But then there are more complex technologies, your IoT, AI, MR, VR technologies. And for each of these technologies, umpteen number of patents exist. So I think it is safe to say that these technologies relating to metaverse are very much patentable. However, it goes without saying that whatever you're trying to seek a protection for needs to comply with the requirements of the patent law in that particular jurisdiction. For patent applications, the assessment is always going to be with respect to what is it that you have claimed. So your claim needs to be novel, inventive, needs to have an industrial applicability, and it also needs to be a patent eligible subject matter. Now this is where a little bit of issues arise, patent eligibility of the subject matter. If you have made, say, a hardware related invention, a lighter AR headset, and you've done some structural changes in the headset to make it light, patent eligibility related concern is not going to arise because it's purely hardware. However, a vast majority of inventions in the metaverse domain qualify as what is known as CRIs in India. CRI stands for computer related inventions, and the definition of CRI is very broad. Any invention having even one feature which has been realized using software, even partially, can qualify as a CRI. And for CRIs, there's a little bit of challenge relating to establishing its patent eligibility. Different jurisdictions have different standards of assessment, but the generally applicable standard is this, that you will have to demonstrate that this invention has a practical application. Now, practical applicability, what really is this? And does this mean that if an invention has been created only to exist in the metaverse, it is ineligible because it does not really have a practical application? That's the question to be asked. And I have an example of a patent, Apple's patent, to be able to, sort of explore the answer. So I request the organizers to now please put up my PPT. I had shared my PPT with you. It's up now. And if I could have the clicker to change the slide, or if you could go to the next slide. Thank you. Yes. Now, Apple has patented a technique to help you deal with acts of vandalism in the virtual world. So you have a virtual house in the metaverse. Your virtual house, of course, has its virtual walls. A vandal enters into your premises, picks up that spray can, and creates a graffiti on the walls of your virtual house. The technique talks about the user being able to remove the graffiti. The user is also able to attenuate the representation of the vandal's avatar in the metaverse. And finally, there's also an option of the user being able to show the vandal the door. So, he will move the avatar of the vandal to a different space. So that's the example. Now, one may argue that this invention does not really have a practical application, at least not in the real world. However, like I said, what needs to be seen is what is it that has been claimed a patent protection for. If you claim a technical process for attenuating content, rather simulated reality content, which is representative of the vandal's avatar's behavior. It has a practical application. Why? Because you can control the representation of the simulated reality content. So, you know, an argument can be made that there is a practical application and the subject matter is not patent ineligible. So there are these eligibility related concerns, but the way I see it is if the invention, having met with all other criteria of patentability, novelty, etc., when it comes to eligibility, if you have an invention which is more than an abstract idea, which is a technical solution to a technical problem, has practical applicability, for these subject matters, patent eligibility is not a challenge.
Yeah, I agree, but I think these are going to be a fantastic product in future. And so do you see any challenges in prosecuting such application vis-a-vis at the global standard? Do we have something which we lack in India, which internationally the prosecution provisions are there, which we do not have? Do you have any thoughts on that?
Actually, I have a mixed response to this. On one hand, we have very good judicial pronouncement, which kind of lift up India's criteria of assessment for CRI's eligibility to that which is akin to the global standards, that of UK, EPO, US. On the other hand, we have some challenges with the practical implementation of those standards with the Patent Office. We do have a CRI guidelines, and I don't mean to be very critical of the IPO. We have come a long way since 2016, where our guidelines mandated that for a CRI to be eligible, there needs to be a novel hardware present. We don't require that. We today are following the test of practical applicability. So the response is sort of mixed. Yes, you do have judicial pronouncements that are good, but the IPO starts to it needs to start applying it in a more robust way, you know.
Yeah, thank you. So I move on to Sriram now. Sriram, what is the trend which you have seen in terms of filing trademark application as digital assets for the purposes of metaverse? And what will be the strategy which you will recommend to the right owners? How to file, how to change their strategy for, you know, a robust prosecution and robust portfolio for protection of their brands, both in real world and virtual world?
The proprietors who, as I already mentioned, the proprietors who are using it only in the real world should also file applications in classes 9 and 42 to cover their registrations so that they can enforce their rights against misusers in the virtual world, and vice versa. Those who are using in the virtual world, irrespective of whether they intend to use it in the future in the real world or not, they should consider filing for the real products as well. So, for the physical products as well. So, it is always advisable to broaden the classification of goods to secure as many registrations as possible in as many classes as possible where you foresee infringement, and get a registration, because Section 28 of the Trademarks Act does give right to a registered proprietor to enforce the trademark against a misuser, and it is not necessary to show use of the trademark.
I agree, in India you can file as a proposed to be used basis,
Yeah.
but what will happen to when you're filing application in other jurisdictions? Suppose you're filing in US or Europe, and where you have to file the user data, then unless you use it, you cannot file it.
Yes.
So how will you strategize? Because the goods are not in place at the moment. How are you going to advise your clients that what should they do? They should wait for the product to come, or they should file it anyways?
Well, I would say then that's also, there's a commercial angle also involved there, because if they are going to file it, then the clients will also have to assess. So it is important to tell the clients what is the commercial implications of filing such trademark applications and prosecuting them further. And in case you're not going to use it in the future, what are going to be the consequences that you will face as a result of not being able to file declarations of use, timely declarations of use. So probably there they will have to assess the situation based on whatever their business decisions are going to be.
So suppose I already have class 9 registrations, may not be for the digital goods. Can I amend the goods and include the digital goods there, or it is not possible to amend the goods?
In which jurisdiction? In US?
In India.
In India, I would say if the class 9 goods are digital goods already,
It's not.
it's not the digital goods. I would say it would be impossible to make an amendment there.
Yes.
Yeah.
Okay. And what kind of challenges do you see in terms of cross-jurisdictional litigation, which you just mentioned in the beginning? What challenges do you foresee, whether a person who is there is an access or can see the metaverse through the, like any electronic gazette, that will be the jurisdiction, so mere accessibility will be the test, or something more would be required to litigate in, to create a jurisdiction and litigate therein?
Yes, so as I mentioned that cross-jurisdictional nature of metaverse is one of the biggest challenge, and be it in perspective of trademarks, be it in perspective of copyright, be it with the litigation point of view, be it with a point of view of a takedown procedure, cross-jurisdictional nature creates a big challenge. So for example, just to take a copyright example, and some content is being, any kind of copyrighted content is being displayed in the metaverse. Now, usually when we talk about our e-commerce platforms, or say for example social media platforms, what happens is that and we file a takedown notice, we send it to an intermediary. What they'll usually do is that they'll take out that content will be taken down, or for example, if there are certain URLs which are country specific, so those can be taken down. So or in case of YouTube, access to that particular jurisdiction can be blocked. But it is very interesting to see how it will happen in case of metaverse. So for example, an infringement is happening on a metaverse platform. How do you think if I send a notice, or if you file a litigation, and that particular copyright infringement can be made out only in a single country and not in other country, because the national law there says that probably it is falling under a fair use exception. So what is going to happen in that case? How do you think you will be able to block access only for a particular country? So that is, one challenge. But yes, to answer that, I feel that yes, accessibility should be how we see what jurisdiction should be there, where is the cause of action arising, wherever there is any kind of right which is being infringed, people should be able to file it in that particular jurisdiction without being able to do that, for example, in terms and conditions you have said that so and so is going to be the jurisdiction. That should not be the test. Accessibility, access to that content, wherever that content is being displayed and the rights are being infringed, that should be the way to go about.
So what you're suggesting is that in the agreement or in the license agreement of use of whatever brand or character you are using, you should not have the ousting clause of jurisdiction. That's what you're advising. Okay, so now we are coming to an end. Just the final thoughts, Jaya, I'll come back to you. Do you have any final thoughts in terms of challenges and strategy in terms of patents?
So, and this is true for patents in any domain, not just patents relating to the metaverse domain. Patents are valuable, right? I mean, they give you a competitive advantage. They are tools for collaboration. They help you attract funding. And it is a known fact that startups with patents have been able to raise more funding. They're evaluated better. Given that patents bring in all these benefits, any growth-driven company in this day and age is already investing in R&D efforts, in procuring patents, doing innovations to come up with innovative solutions for their consumers. How they can align their existing approach to the innovations happening in metaverse is to see if metaverse-related technologies can be applicable to their existing business and realign their strategies accordingly. I'll take a Nike example. You did take one too. So in this example, Nike, known for selling its sneakers, has brought in blockchain technology. And so when a customer is buying a physical pair of sneakers from Nike, he can also obtain a digital token. And that token can be used to verify the ownership of this pair of sneakers with this purchaser in the real world as well as metaverse, right? So they've used a metaverse-related technology to augment what they're doing in the real world. And this kind of applicability is something that is an example of how metaverse-related technologies can be explored, and therefore R&D efforts can be made into exploring it.
Yeah, thank you for that comment, because this is the biggest marketing boom, which I think right from Nestle to Morris Garages to Gucci, all of them, because Gucci in one of their promotional campaign using metaverse invited all the players to try their clothing and kind of showcase their avatars on the platform. So that was one of the very well received, but for that you have to buy the real good and you will get a token to try, and you can even use it on any gaming platform. So these are one of the biggest, and likewise Nestle also did one of their Munch campaign where they invited Indian players, where users can go and interact with the Indian players, and they were sharing Munch and all of that. So this is going to change at least the advertisement dynamics and the environment of the country. So a lot to be looked into. So coming back quickly to you, Sriram, what is your final takeaway? What is the kind of, how do you feel that the prosecution trend will change in India or abroad?
There are a few challenges from the perspective of the Indian Trademarks Act that we may face. For example, jurisdictional issues which have already been discussed, how to structure the assignment and license agreements revolving around metaverse-related products having metaverse-related trademarks, how to prove use of a trademark, how to generate examination reports for trademarks related to metaverse. So what kind of documents would corroborate use of a trademark in relation to metaverse? Would that be copies of smart contracts? Would that be screenshots? Or anything else like an audio or something like that? Or coming back to the examination report part, when examination reports are generated, typically what happens is that the goods in the same class or the trademarks in the same class are attached to the examination reports as search reports. These are the conflicting trademarks. So, for example, if there is a trademark for downloadable virtual goods being playthings in class 28, so, or downloadable virtual goods being furniture in class 20, in class 9, these products are all going to fall in class 9 so long as they are downloadable virtual goods. So if they are going to conduct a search in class 9, will they have all these similar trademarks with different goods, different virtual goods falling in the same class? Will those be cited against the trademark, or will there be a stricter scrutiny? Or do the examination standards or the examiners will have to tweak the way they generate the examination reports to ensure that not all the goods in class 9 come in as conflicting trademarks, are not cited as conflicting trademarks in the search report? So that could probably be a challenge, how the trademarks are being examined.
Yes, I agree. So do you also think that this metaverse is going to give an opportunity to the brand owners to monetize their brand in a third-party event? For example, in a brand promotion experimentation, Abhijit and Saraswati, they had a live wedding on metaverse, wherein ITC used their Feeble chocolate and matrimony.com became the kind of partners to promote their brand. So in future, do you think that the brand owners will not only have the protection of brand, but they can also lend their brand in a third-party event where they want to use their brand? Suppose have a Kit Kat or have a break, have a Kit Kat, such kind of logo or such kind of slogan somebody was to use during some event, they will have to take permission from Nestle or from the Kit Kat brand owner. So it's not only the prosecution, but also there is an opportunity in the metaverse to monetize it by lending it also. A lot of licensing and cross-licensing is going to happen. What are your thoughts on that?
Yes, certainly. It will definitely give an opportunity to the proprietors or the owners of those brands to monetize the brands, not just from the prosecution perspective, but also transactional perspective. So licensing, franchising, all these things will definitely take shape, and it is going to these are better business opportunities for the brand owners to lend their trademarks, lend their brands to third parties for the purpose of using in the metaverse.
Yeah. So thank you. One more last question to you is that you just mentioned that takedown, and we all are very familiar with online infringement and takedown. What is the challenge in metaverse in takedown mechanism? Because it's not Web 2, but it's Web 3. And Web 3, the ownership shifts, there is no registrar. So how are you going to approach the takedown mechanism, because it's all NFT land-based and the consent-based and the voting-based. So it's going to be a very complex exercise as against a simple takedown notice. So what are your thoughts on that?
So yeah, as I said that takedown procedure is going to be difficult in metaverse, not just for exercising takedown, but for implementing takedown as well, depending upon from which country the infringement issue is coming up. So a lot of such platforms do have, firstly, you will have to see what is the takedown mechanism given on that particular platform, and then you need to follow the same. How it is going to be implemented is, yes, a challenge, because then the platform will have to see, is it possible for the platform to block access for a particular jurisdiction or not, and that is something that the platform needs to develop in that case. There have been, issues, current scenario, the current laws and the framework that are in place may not be completely adept to dealing with metaverse, be it in case of litigation or be it, as we are talking about, in case of takedown mechanisms. I think a lot other things have to be done. For example, even the metaverse platforms need to come up with the automated detection tools. So for example, even a right owner may not have to send a takedown notice, but their automated detection tools should be able to recognize in case any kind of infringing content is being uploaded, so that an automatic notice can be sent to the uploader, whosoever has uploaded the infringing content. Of course, apart from that, there can be, for example, the IP owner. They should be able to share their digital fingerprinting policies, so that in case any kind of unique content belongs to an IP owner, so via the way of digital fingerprinting, the metaverse platform can get to know in case a same content has been uploaded. Of course, we will have to make some refinements in the laws that exist. The laws that we have right now for the physical world can be used for metaverse, but some more refinement is necessary, so that we make these metaverse platforms, we put them, we make certain regulations that so and so, like we have regulations, we made it for, in case of e-commerce platforms, we came up with the intermediary guidelines. We need to come up with such guidelines for metaverse platforms as well, so that a proper framework has been laid down, and they come up with such automated tools, and they have a proper policy in place in case such takedown notices have to be sent, and how they are going to implement it, that should also be noted down properly. Apart from that, I think other thing that should be there is that you have to make sure that they do have a content moderation policy in place, all these platforms. Other than that, what is important in case of takedowns as well as in case of litigation is a concept which probably all the countries need to come together and think about, is harmonization of IP laws. Because now that we have changed from physical world and we are going to a virtual world where this cross-border dispute is always going to be there, maybe we really need to think about harmonization of IP laws, so that local differentiation in local laws and differentiation in national laws do not become a challenge every time a new dispute comes up. So this harmonization is really important. The exception, not just harmonization of laws, but also the exceptions that are given to certain, like for example, I mentioned about the fair use exceptions. Harmonization is important. The other thing that we need to focus on is probably have an authority which looks after cross-border disputes, which looks after in case any kind of infringement happens, which is crossing boundaries. So if there is one established authority for that, that would really help.
I have already been reminded twice for the time being up. So, as you all may notice that though metaverse is a very challenging and interesting dream world, but it also throws a lot of challenges. I would like to thank my panelists for being here and will welcome any questions through email because we are running short of time. Thank you all.
Any questions? So, as we conclude, let's carry the collaborative spirit of this session into the challenges that lie ahead. Thank you to our exceptional panelists and moderator for their crucial role in making this session informative, engaging, and enjoyable. I just request the moderator to please present small memento to all three of them, and I will be privileged to give it to you.